Hello, everybody. Welcome to Law Made Simple and Comprehensive. I am Negrikoza. Today, I would like us to focus on Administrative Law ADL 2601. We're going to look at the first assignment. Set of facts. The Minister of Transport decides to close all taxi roads and the portion of the taxi ranks operated by the Mangaung Taxi Association, MTA. The minister plans to introduce a new bus service system, which has commonly become known as the Batubili (BP). The purpose of the BP is to improve public transport in the Northwest Province. MTA is aggrieved by the decision of the minister and points out that the BP can be implemented on other roads where no form of transport is available, and furthermore, that the consequence will be that its 900 members would be without jobs. MTA has persistently tried to make these representations to the minister. The minister has refused to receive their representations and has made no attempt to give reasons for the decision to close all taxi roads and the portion of the taxi ranks operated by MTA. MTA, contact you. Advise MTA on the following and give well-substantiated reasons for all your answers. Question 1A. Briefly explain what an administrative law relationship is. Do you think MTA is a subject of an administrative law relationship? Now we are first going to focus on the first part of question 1A, which says briefly explain what an administrative law relationship is. I am on page 20 of our study guide. I'm not saying that this is exactly where to get the answer, but if you read through from the first page up until here, you are going to get exactly what is a relationship, what ADL relationship is. What I've noticed when I went through this assignment is that there are many terms or words that I need to explain, but I cannot really do it right now because it's just going to take forever. But if you guys feel that there's a need that I need to try and clarify some things for you, you can just leave a comment on the comment section just below the video there, and I would gladly do so, because there can be a confusion if you don't really understand some other terms here. But for now, I'm just going to focus on the assignment and leave out the explanations of the terms and whatnot. Okay, what I have actually gathered when I read through the guide is that administrative law relationship exists between two parties in an unequal or vertical relationship. One of the subjects is a person or body clothed in state authority or organ of state who is able to exercise that authority over a person or body in a subordinate position whose rights are affected by the action. So when we take a closer look at our scenario, we realize that we have the Minister of Transport, who is the state organ of state, and we have our MTA, the Mangaung Taxi Association, which are in a subordinate position. So the transport minister is exercising his power or state authority over the Mangaung Taxi Association. They are at the receiving end. Whatever the minister decides is going to affect the rights and interests of the Mangaung Taxi Association. And do not make a mistake, guys. When you answer this question, you must make sure that you answer it in a form that you are still going to include the facts that are given to us, because here we are advising. So you cannot just take what's in the guide and write it down just like that. Where is the advice there? But if you also include the set of facts that we were given, that will be a form of advice, and your answer is going to be correct. You can simply say that according to our set of facts, the Minister of Transport is exercising state authority when he decides to close all taxi routes and the portion of the taxi rank operated by the MTA, and plans to introduce a new bus service known as Batopili. So now we know that the rights and interests of the MTA are affected by the minister's decision, because when we read through our set of facts, we get that if the minister decides to close those taxi roads, 900 members of the MTA are going to be unemployed. So their rights and interests are affected in that manner. The second part of the question: do you think MTA is a subject of an administrative law relationship? Yes, MTA is a subject of an administrative law relationship because they are in a subordinate position. They are at the receiving end of an what? I don't know, of the law actually. And we do not have to forget that MTA is a legal subject. They have rights, they have everything. So you can simply say that the MTA is a subject of an administrative law relationship because it is a legal subject in an administrative law relationship. And further say that the MTA is in a subordinate position. In other words, the MTA is receiving authority from the public power by a functionary in authority. You get that? Yeah, that's how it's supposed to be. But do not write exactly as I'm saying, because you're going to be penalized with plagiarism. Just use this video as guidance, on how you're supposed to structure your answers. B. Identify the organs of state in the set of facts and substantiate your answer with reference to the definition of organ of state as provided in the Constitution. Okay. Um, According to our set of facts, our organ of state is the Minister of Transport. But how do I know that? Let's quickly check. Page 7 of our study guide defines organ of state as: organ of state is defined in section 239 of the Constitution and includes any department of state or administration in the national, provincial, or local sphere of government, or any other functionary or institution that exercises a power or performs a function in terms of the Constitution or a provincial constitution, or exercises a public power or performs a public function in terms of any legislation. However, a court or judicial officer is not included. Okay, so now we have found that an organ of state exercises a public power or performs a public function. So who was exercising power here? Is it the MTA or the minister? Of course, the minister is the one who has the authority here. So our answer is the minister has state, is the organ of state. And we have already answered the second part of the question because yeah, we have already answered that. They are saying here that we should substantiate our answer with a reference to the definition of organ of state as provided in the Constitution. So we have already read out what the Constitution is saying according to section 239, I'm sorry. So your answer is supposed to be like that, but forget, do not plagiarize, just put it in your own words. If you want to plagiarize, just put inverted commas. You can even cite or do something. C. Does the decision to close all taxi roads and the portion of the taxi ranks operated by MTA constitute procedurally fair administrative action in terms of perjury? Okay, now what we're supposed to look at is what does procedurally fair actually mean? When something is procedurally fair, what is the meaning of that? Guys, I came on this page 13 of our study guide so that I can read where it says to be procedurally fair just here. But I just feel the need to read everything which is written here, so that you can really understand what is actually going on. I won't be able to read out everything. I'm just going to start here and read out, then I say out my answer. Maybe in that manner you are going to agree with me on my answer. You will know how I got to decide that this is the actual answer that they are looking for. Okay, it says here, let us look at these 4 requirements for just administrative action. For any administrative action to be lawful, it must comply with all the requirements of the law as found in the Constitution, the relevant legislation, common law, customary law, and court decisions. In short, the sources of the law. To be reasonable, it must have a reasonable effect or result. This means that when the person in authority exercises his or her discretion and takes a decision, such a decision must be correct in that it is based on objective facts and circumstances. In short, the decision must be sound and sensible to the extent that a person may say, although I don't agree with the result of the decision, I understand why the decision was taken by the administrator. But when we look at our set of facts, let me just go there. We find that the MTA is aggrieved by the decision of the minister and points out that the BP can be implemented on other routes where no form of transport is available, and furthermore that the consequences will be that its 900 members would be without jobs. MTA has persistently tried to make these representations to the minister. The minister has refused to receive their representation and has made no attempt to give reasons for the decision to close all taxi routes and the portion of the taxi ranks operated by MTA. So when we look at that scenario, where is the reasonableness? There's actually no reasonableness because the minister just doesn't want to hear anything, and he actually doesn't care, like he doesn't want to be convinced whatsoever, like he just doesn't give a damn. Yeah. So let's get to our second point. To be procedurally fair, the correct procedure must be used to take a decision. This in turn means that the subordinate party must be given the opportunity to explain his or her position or present his or her side of the story before any decision is taken, and that the person in authority must act impartially, not be biased or prejudiced. in exercising his or her power. So according to our set of facts, the minister doesn't want to like, okay, what can I say? He's not allowing the MTA to make any representations to him. So that is not fair. He is not procedurally fair. He's not following protocol actually. And the MTA, since they are in the subordinate position, they're not given an opportunity to explain or present their side of the story, like, hey guys, okay, just look at this. Wait, okay, no, yeah, let's start here. I'll just quickly read there. Yeah. The subordinate party must be given the opportunity to explain his or her position or present his or her side of the story before any decision is taken, and that the person in authority must act impartially in exercising his or her power. But when we look at our set of facts here, we find that the minister has already decided. He has already decided to close the taxi routes. So this shows that the minister did not follow protocol. He is not procedurally fair to the MTA. He is abusing his state power, if I can say that. He is biased, actually. He is impartial. So these are the what? I don't know. These are the facts that you can try to state when you give out your answer, and when you want to just include something which are in the set of facts. I think we have understood what procedurally fair administrative action is. What does it actually mean? So now our answer is supposed to be like this, ne? For a good understanding, you can start reading from page 131, but the actual answer is just below that. Our actual answer is on 133, ne? Section 3 of the page, where it says that the discretion requirements for procedural fairness are listed in section 3 of the page. The aggrieved party may be given an opportunity to obtain assistance, even legal assistance, in complex cases. The aggrieved party may be given an opportunity to present and dispute information and arguments. The aggrieved party may be given an opportunity to appear in person. So I'll read the question again. Does the decision to close all taxi routes and the portion of the taxi ranks operated by MTA constitute procedurally fair administrative action in terms of PAJA? Our answer is simply supposed to be no. Because the minister did not comply nor consider any of these requirements above. The MTA was not given an opportunity to obtain not even assistance, but to present their side of the story. And they were not given an opportunity to dispute information and everything, like the minister just did everything his way and did not give them a chance or opportunity to do anything on their side as well. So our answer is supposed to be no. Our final question of the first assignment says D. Explain the concept of proportionality with reference to the reasonableness of the decision to close all taxi routes and the portion of the taxi ranks operated by MTA. Okay, we're going to go to our study guide on page 125. Ne? This is where we get proportionality. I'm just going to read through here. It's quite a long text, but if I don't read through, you're not going to understand why I answered the way I did. So let me just quickly do it. Okay. The judge's reference to the three requirements of suitability, necessity, and proportionality relates to the question whether reasonableness or justifiability includes adherence to proportionality as well. Proportionality relates to the means or method used to achieve the purpose, whether the means are proportional to the purpose. In short, is there an even balance between the means used and the ends envisaged? Proportionality requires that in achieving a statutory purpose, the harm to the individual should not be disproportionate to that which the community gains. Okay, now, what is proportionality? You just have to try to summarize this. Try to summarize this as short as it can be, you know? Yeah. As short as it can be, ne? Okay, yeah, let me just continue reading. We're going to summarize after. It is also worth knowing that the suitability, necessity, and proportionality referred. It is also worth knowing that the suitability, necessity, and proportionality referred to by the judge are the three elements of the principle of proportionality known as, I don't know how to read that word, in German law. An administrative action will pass the proportionality test in German law when the following elements are considered and found present. The suitability of the administrative measure, the necessity of the measure. 3. A weighing up of the advantages and disadvantages when considering the end, purpose of objective to be attained, narrow proportionality. 1. Suitability. In accordance with this requirement, when exercising his or her powers, the administrator must choose only those means from the variety of means available that are most appropriate for achieving the desired end. This element is more or less the same as rationality. In other words, there must be a rational connection between the end and the means. 2. Necessity. Necessity means that the administrator must take only such steps as are necessary if any prejudice to an individual is involved. In other words, the administrator must choose the action that causes least harm to those who will be affected by the measure. But when we look at our set of facts, we can see that the administrator chose action that causes more harm to the community, actually. Because can you imagine a number of 900 people losing their employment? Okay, 3. Weighing up advantages and disadvantages. This is a very important requirement in that it requires weighing up the advantages and disadvantages and considering the injury to the general public or the individual. The method or means must not be out of proportion to the advantage, the ends to the community. In short, proportionality requires the achievement of an even balance. Okay, we can try to summarize this by saying that the proportionality principle means that the harm to the, or maybe I should just read the question again. I don't know. But yeah, it's okay. Let's just go. There's no time anymore. The proportionality principle means that the harm to the individual should not be disproportionate to the benefit to the community. The principle of proportionality has three elements. Then now we're going to mention the suitability, necessity, and weighing up advantages and disadvantages. And we notice that oh guys, I don't know what I was even saying. My sanity here is so disturbing me right now. Okay. But when we look at our scenario, we can see that the decision taken by the minister is actually causing more harm to the MTA or actually the community than good, So this proportionality is not working. So when we look at suitability, we can simply say that this requires that the administrator taking the decision to use the most appropriate means available for achieving the purpose, a rational connection between the means and the end. Necessity. The administrator may take only those steps that are indispensable to achieve the purpose if it involves harm to the individual or the party, actually, because now we're talking about a party, which is the MTA. In other words, the administrator must choose an option that will cause least prejudice. Third one, weighing up the advantages and disadvantages, also known as narrow proportionality. This is okay. This demands that the means must not be out of proportion to the end in balancing the outcome against possible harm caused. So we can simply try to relate to our set of facts by saying that the decision to close all taxi routes and the portion of the taxi ranks operated by the MTA does not comply with the three elements of proportionality. There is no rational connection between the decision to close all taxi routes and the portion of the taxi ranks operated by the MTA and the improvement of public transport in the Northwest Province. The closing of all taxi routes and the portion of the taxi ranks operated by the MTA does not seem to be indispensable steps to achieve the improvement of public transport in the Northwest. The disadvantages outweigh the advantages. So, guys, this is the end of our video. Actually, you know what? This is the end of our first assignment. I think that it would be best if we can also focus on the second assignment as well, because sometimes you find that I do not have time to try and I do not have time to record the second assignment or the next video or something like that. So I think it's better that we just get on with it right now. Okay, now we are going to look at assignment 2 of ADL, the multiple choice questions. Question 1. Which of the following is a characteristic of an administrative law relationship? The answer is 3. The organ of state forces the subordinate party to act in a certain manner. Yes. Question 2. Which one of the following is not an organ of state? The answer is 1. The Constitutional Court. You remember when we read the definition of state organ on page 7 of our study guide? No, organ of state, not state organ. Sorry. It mentioned just at the bottom of the definition, the last line, that the court is not included in those things. Third question. Administrative action is defined in section 1 of PAJA. Which one of the following examples complies with this definition? The answer is 4. An officer in the Department of Health decides to appoint Ms. Molloy as the architect to design a new state hospital. 4. Just administrative action is regulated in section. The answer is 4. 33 of the Constitution. 5. Deconcentration is a form of delegation. Which statement refers to this form of delegation? The answer is 1. This type I'm sorry guys, hey. This type of delegation takes place within an internal hierarchical system where we encounter different ranks of administrators. If you can quickly look at page 100 of your study guide, you are going to agree with me. The courts have been hesitant to pronounce on the reasonableness or unreasonableness of administrative action through their power of review. Judicial intervention was permitted only when the degree of unreasonableness was so gross that something else could be inferred from it. The following court decision illustrates or supports this view. The National Transport Commission versus Churches Motor Transport. You can find this on page 127 of your study guide. Question 7. The rules of natural justice is a collective term of a number of common law provisions applicable to administrative inquiries and hearings. All of the following form part of the rules of natural justice, except the answer is 2. The doctrine of legitimate expectation. 8. Any person whose rights have been materially and adversely affected by any administrative action may request written reasons. Which one of the following statements is correct? My answer is 3. The administrator must provide written reasons with 90 days of making his or her decision. I found this on page 197 of the study guide, and my friend says the answer is 4. So I just feel like you guys need to just do a checkup, just try to verify. 9. Which one of the following is not an example of or a form of internal control? The answer is 3. Judicial review. This is found on page 164 of your guide. And the last question, which one of the following is not a ground for judicial review in terms of section 6 of PAJA? The answer is 2. The administrator acted in accordance with the provisions relating to time. The only difference here is did not. You are going to find this on page 180 of your guide, and you are going to agree with me. Okay, guys, I still stand by my word that if there's a demand of some clarification, explanations, or something, just leave a comment on the comment section. I am going to gladly and willingly summarize the whole guide and explain everything to you and do everything that is necessary, all just for you. If you're new here, please subscribe and make sure that you stick to the right group. Okay, guys, thank you very much for listening and your time. And please, guys, focus on your studies. Do not plagiarize. Keep well, keep safe. Peace out.